Are you Christian Kane?
Yes, ma'am.
We're going to lesser.
Yes, Your
This is clause number 24, DCCR 1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial, sent to the John Donne Behavioral Science Center for Competency Restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from Dr. Liberis with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
Right, then at this time, based on the two reports I am going to find.
Right away. This hearing starts with something extremely important that a lot of viewers overlook: competency restoration. That means the court previously believed the defendant was not mentally fit to understand the legal process. But after treatment and evaluation, doctors now believe he can participate in his defense. And notice how quickly the judge confirms it once both reports line up. In court, once two professionals agree on competency, the case can move forward fast.
That Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24, DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification.
This is actually a major break for the defendant. Originally facing something more serious, the state drops down to a lesser included misdemeanor offense. That usually means prosecutors weighed the risks, the mental health history, and the practicality of trial. But here's the trade-off. By taking plea deal, he avoids uncertainty, yet gives up the chance to fight the case later. Would you take a guaranteed lighter sentence, or risk trial hoping for complete freedom?
Shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Lucius LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LaFleur, in cause number 20-33730, I have a motion to revoke your community supervision. This shows that you were placed on probation November 3rd of 2021 for the third-degree felony offense of theft of material, and that was a 7-year term in prison that was probated for 10 years. Is that correct? And the motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of a Class A misdemeanor assault September 11th of 2023 in Angelina County, Texas. And is that true or not true? Count 2 alleges that you committed the offense of possession of a controlled substance January 23rd of 2024 in Angelina County, Texas. Is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of April, May, June, July, August, September, October, November, and December of 2023 and January of 2024. And is that true or not true?
True.
And this is where probation cases start collapsing fast. Missing reports month after month is already dangerous territory. But combine that with a new assault allegation and a drug possession charge, that turns probation from a second chance into evidence that the court's trust was completely broken. Judges usually look for effort, accountability, and consistency. Here, the repeated violations stack up like dominoes.
You guys have an agreement, right? Do I need to keep going, Mr. Coleman?
That's all I was looking for. That is a statement.
All right, this is where things get serious fast. When a defendant pleads true to multiple probation violations, they're essentially admitting they broke the court's trust not once, but repeatedly. And here's the kicker. Probation is already the second chance. So the real question is at this moment, is there any path left that avoids prison time? Or is this outcome already locked in?
They were waiting to remain.
All right, so stale abandoned 4 through 6. Mr. LaFleur, did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're actually true?
True.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
True. Yes, it is.
Thank you. And do you fully understand them?
Yes, I did.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
Listen carefully to that phrase. Waiving your right to appeal. That is one of the biggest powers plea agreements carry. Once the defendant agrees and the judge follows the deal exactly, the case is basically locked shut. No dramatic courtroom comeback later. No surprise reversal. Just a binding agreement entered into the record permanently. Quiet moment, massive legal consequence.
No objection.
It's admitted. Is there any evidence that Mr. LaFleur is not competent?
No, Your Honor.
All right, sir. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm trying to print, and it's just... I'm going to hand you the trial court certification that shows this was an agreement, so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because your probation you've been on it for a while, I'm not sure that you got this when you initially got on probation. But because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead...
There it is. The moment probation officially dies. Notice how calm the courtroom stays while someone's entire future changes in seconds. No yelling, no cinematic breakdown, just a judge methodically revoking freedom and converting that suspended sentence into real prison time. That calmness is what makes these hearings hit even harder. The system does not always move loudly. Sometimes it moves with terrifying efficiency.
Charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
And just like that, it's over. 2 years, locked in by agreement, with no appeal. This is one of those moments where the system moves quietly but decisively. No dramatic outbursts, no last-minute twists, just consequences catching up in real time. But here's something to think about. Do plea agreements like this truly serve justice, or are they simply the fastest way to close a case? Let me know what you think.
And the hearing ends with something many defendants underestimate: the long-term consequences after sentencing. restrictions on firearms, permanent criminal records, employment barriers, those effects can last far beyond the prison sentence itself. So here's the bigger question for everyone watching. Should probation violations automatically lead back to prison as quickly, or should courts focus more on rehabilitation before incarceration becomes a final answer?